number 79, Matter of Koegel. Let's just wait one moment, counsel, till your colleagues clear out. Counsel, good afternoon.
Good afternoon, Your Honor. May it please the court, my name is Andrew Himmel from Himmel and Bernstein, and I represent the appellant, and I would like to reserve 3 minutes of rebuttal time.
You may have 3 minutes, sir.
Thank you, Your Honor. The key question, the core question before this court is whether this court should allow for judicial cures of materially defective acknowledgments, or whether this consideration is best left for the legislature. The court in Goleta held that the defect in this case was substantial and material because the certificate failed to include all necessary statutory language in the certificate. And the RPL, the Real Property Law 306, states that a certificate must include this language. It uses the word must, and as this court has held, when a statute uses such mandatory terms, such as must or shall, the effect is peremptory. I mean, unless there is...
Counsel, if I can interrupt you, I'm on the screen. Thank
Yes,
you.
yes.
This case is very close to the hypothetical scenario presented in Goleta, which, given the way that hypothetical is presented, does suggest that the court thought, at least at that time, that perhaps it made sense when actually everything that is statutorily required is done, in fact, but is not properly articulated in the document.
Okay, Your Honor...
But the underlying facts cannot change, right? That is what happened here. Everyone agrees that the one thing that's missing is that proper acknowledgement, not that there wasn't an acknowledgement, but rather the documentation that there was a proper acknowledgement.
Your Honor, you're referring to the Goleta dicta, and what I would say to that is there's no hierarchy of the importance of the requirements for a valid acknowledgement. Part of the problem of the Goleta dicta was that it assumed that the first two requirements, the oral acknowledgement and the prohibition about a notary taking the acknowledgement unless he knows the signer or has evidence of such, it's not as if those two requirements are the important ones and the third one is not important. So there are three requirements, and Goleta...
Well, no, I'm not suggesting they're not important. I want to clarify sort of the context of my question.
Sure.
Because that would mean that we would jettison the requirement, and I think it's very clear that that's not what we're talking about here. The question is whether or not one could provide that requirement subsequently if the rest had been done in fact. Right, that's really the question.
Your Honor, I think that what happened...
I mean, the acknowledgement occurred, correct?
It did not. Well, it depends what you mean. The oral acknowledgement occurred.
Correct.
Step one. The
Yes.
notary knowing the signer, step two, that did take place. But the fact that the third requirement did not take place renders this defective. Which
Yes,
is
but although there's no hierarchy, all three are requisites. I'm not disagreeing with you about that. But the first two go to that heart of the party, right? The signer or the signers, knowing that they've made this choice, that they are foregoing perhaps some great benefits, or at least they understand the consequences of signing the antenuptial agreement. The last part, they might not even know that there's a problem, right? I mean, that's what Goleta says. Look, through no fault of their own, the parties are trying mightily to comply. They're doing what they need to do. Through no fault of their own now, the nuptial agreement would be held unenforceable when this is something that can easily be cured, because it's not about going back in time to do something that wasn't done. It's merely to properly document that it was done.
Well, Your
Right?
Honor...
That's the difference. Isn't that the difference? That you actually did do these things. It's about, as Goleta says, conforming the actual events with the documentation.
Well, the conforming of the actual events was the language that Goleta used in Goleta dicta. But what happened here was because the language was not placed into the certificate, I think the presumption in your question, Your Honor, is it really goes to the heart of this, is should cures be available in the first place? And it is appellant's position that there's no source of any authority for the judiciary to so act. There's no statutory.
Well, I think if I could just, I'm not going to disagree with that latter point. That's your argumentation. Certainly you may proceed with it. But I think really the question before us in this case is whether or not the evidence presented to address the gap was acceptable, given the statutory mandates. It's not whether or not sort of writ large, the judiciary can go about the business of saying anything you want to do to cure your errors or mistakes or the deficiencies is okay. We're only talking about this one, which is everything happened as it should, as a matter of fact, but you don't have the proper documentation of one aspect of this that is outside the control of the signatories.
I don't believe that everything took place that is supposed to take place, Your Honor. That is our position. Even though it was out of their control, there's no statutory provision that says so long as it's out of their control, that can dilute the application of the third requirement. The third requirement is a material defect, which is exactly what Goleta held in any event. So the Goleta dicta, with respect to the Goleta panel, is in conflict with the holding of Goleta. This is a material defect. And in terms of whether there can be evidence to bridge the gap, that I think is just another way of saying should cures be available in the first place, and it's appellant's position that there is no source of judicial authority to provide that cure. There's no statutory grant, there's no constitutional grant, and this does not fall into the doctrine of inherent judicial power, because that relates to a court's ability to exert power because it's a court, to control its own business. That doesn't apply here, where the legislature has so heavily occupied this area.
Counsel, let's assume for a moment that a cure is permissible. Are the affidavits that were submitted by the notaries here sufficient?
Yes, if this court does what it has never done before, which is to allow for a cure under the acknowledgement method, then the Jacobson affidavit would be a cure. But I have to hasten to add that it would not function as a subscribing witness statement. It is completely defective as a subscribing witness statement. It only gains vitality if this court, as I said, creates a new path of validation, which currently simply does not exist.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. Can you hear me?
We can hear you.
Good. I'm Susan Reed. I represent the executor of the estate, John Koegel. There are three areas that I would like to address. One is why the 1947 amendments, among other things, completely undermines Ms. Kogel's statutory interpretation argument that you just heard, that a waiver with a deficient certificate may never be validated or cured because the legislature did not use the word cure. The second area I would like to cover is why the rule, the bright line rule that she proposes, is uniquely terrible and unfair. And lastly, what the rule would be going forward. In referring to the 1947 amendments, you have to remember that the text of the law originally said that during the lifetime of the other, that the waiver had to be subscribed and duly acknowledged. Then the court, the surrogate in Erie County decided Matter of Koegel, which eventually made its way up here. It was affirmed without opinion. That was a case where there was absolutely no certificate. But he found that relating to the real property law, the surrogate subpoenaed a subscribing witness. There was a subscribing witness, and took the testimony from the subscribing witness that he'd been present, that he knew the Linda Mall, who executed the waiver, and then the judge issued the certificate. The Law Revision Commission thought that rule should be codified in order to liberalize the acknowledgement requirement. And they did that by setting up two co-equal, and that's co-equal, not mutually exclusive, ways to validate a waiver, and that was the acknowledgement method and the subscribing witness method. It seems to me impossible to conceive that the legislature amended the law specifically to allow evidence from a subscribing witness to validate a waiver where there was no certificate of acknowledgement, but would not to validate a waiver where there was a certificate, an acknowledgement and a certificate, and the notary did everything he or she was supposed to do other than include all the proper language in the certificate. The surrogate below made a specific finding that the affidavits were sufficient because they were based on the notary's personal knowledge of the signers and their actual observation of the signing. Now, the surrogate below, and I understand from what my adversary just said that he thinks this should have happened, but the surrogate below did not consider it necessary to call the two subscribing witnesses for any kind of live testimony to this effect, to have them give their addresses, and then for him, the surrogate, to issue a certificate of acknowledgement. I didn't say that, he didn't say, my adversary didn't say at the time that that would be necessary, and there is certainly no doubt the surrogate would have done this if asked. Why is this bright line rule that's being proposed uniquely terrible? Well, I would say it's always unfair, because what we're talking about here is a paperwork error. There's no fraud, there was no overweening of somebody's will. It would reward someone that got exactly what she freely bargained for, agreed to, at the expense of the beneficiaries, which is often, as it is in this case, the children of the testator's first family. And it's particularly unfair here where it was mutual. It doesn't have to be. Waivers can be unilateral. But in this case, it was mutual, which means that Ms. Koegel has gotten the full benefit of her bargain. When these two individuals married in 1984, she was 54, he was 60. There was no way of telling which one would outlive the other. She has basically received the full benefit of that bargain. And it would be like somebody who tries to rescind a contract when you can't restore what the situation was because, of course, Mr. Koegel has died. I think, too, that there's no offsetting benefit that you can find to this rule that they propose, because today there's a form. In 1984, there was not. So it's not as though the court's going to make anything clearer by saying that by adopting the bright line rule that my adversary suggests. There still will probably be typographical errors. There will still be law office failure, which is likely what happened here. But for the most part, the bench and the bar absolutely understand what's required. As I said, there's a form. You can just get the form and fill in the form. I also would point out, in terms of the unfairness, that this is not an equitable distribution case. The surrogate cannot account or compensate in the award for the separate property that Ms. Koegel brought to the marriage. She can't account for her assets at the time of the death. All you would have here is 1/3 of the net minus statutory deductions. At least in equitable distribution, if the prenup is thrown out, as if it's not effective in the matrimonial action, and that's what 236B3 says, that you can't use it in a matrimonial action if it's not properly acknowledged or proved.
Counselor?
Yes.
One of the things that strikes me is that in both the cases today, there's an argument that any change in the strictly prescribed procedure would create too much flexibility and essentially reduce it to a jury question and a question of fact that has to be submitted to a trier that would make it difficult for the practitioner to know how to operate. How do you respond to that?
Well, I think in this case, as I said in my brief, there are very few things that can go wrong. There are very few factual issues that can be presented. You
But
either...
as you know, inevitably something will.
Well, sure. Inevitably, there'll be a problem, and inevitably, somebody will leave something out.
Mm-hmm.
But you have to do two things. You have to say, I either knew the person or took actions to make sure that the person who signed it was the person described. You have to take the acknowledgement have the declarant has to
So
acknowledge.
do you think it's the nature of what needs to be cured that distinguishes this case and doesn't make it totally arbitrary?
I'm sorry,
You think it is the nature of what needs to be cured and removes this case from something that would be a totally arbitrary cure?
I think it's the nature of what needs to be cured that makes what has to be done pretty obvious and doesn't really create any messy issues of fact that have to be either considered by the trial court or given to a jury.
Because that's the danger, I think, is those, as you put it, those messy issues of fact.
Yes, that was what Judge Kay said in Matisoff, was one of the problems she had in the Matisoff case, because you would get into an argument there about whether the two individuals during the course of the marriage had carried out their original intent. That's not the situation here.
Thank you.
I think the rule here should be at a minimum, the rule in the EPTL area actually, as it's been understood by surrogates through the years, is actually narrower than the Galetta rule, although I think the Galetta rule is a fine rule. But the rule, it seems to me, that in the EPTL area should be at a minimum that a spousal waiver with a defective certificate of acknowledgement is nonetheless valid and enforceable where the surrogate finds that the notary or other official who assigned the certificate knew the signer and observed the signer execute the waiver. That's a very simple rule, and it's a very narrow rule.
Thank you.
If there are no more questions,
Thank you, counsel.
thank you.
Counsel, you have your rebuttal time.
Thank you, Your Honor. A few points. These are co-equal and distinct statutory provisions. The subscribing witness method and the acknowledgement method. We know this from Galetta because the husband in Galetta tried to cite Maul, that's the 1941 case that led to the 1947 codification. The husband tried to cite Maul as support. And this court, I believe it was in footnote 4 of Galetta, said no. Why? Because Maul is a subscribing witness case. It is not an acknowledgement case. So Galetta fully understood that these are separate and distinct approaches. The second point I want to raise is that my adversary has referred to this as a paperwork error, a law office failure. This is another way of saying this third requirement's really not all that important. The first two ones, that's what's really important. But the third one, setting forth the language, that's not so important. And if you blow it there, it's just a paperwork error. Not true. And we know that that's not true because Galetta said this is, in fact, a substantial error. The third point I want to make is that there was some discussion here about the benefit of the bargain. Now, you can line up the equities. Yes, there's an argument from respondent that she benefited, my client, from the bargain. The bargain is that William Koegel would take care of all of her expenses. My client can argue she was rushed into signing a prenuptial agreement 1 week before the marriage. This parade of equities can go on, but to link the question of whether a cure should be available to a weighing of the equities, that's a terrible idea because it makes this a hopelessly fact-oriented inquiry which it provides absolutely no consistency.
But counsel, I thought that, you correct me if I've misunderstood the record, I thought that she did admit that when she signed this, she thought it meant what's hers is hers and what's his is his.
The very next sentence, she said that in her deposition, the very next sentence in her deposition, which is page 200 of the record, is she said, but I had no idea that after 29 years of marriage, after Bill died, I would have no standing. So that's in the record. But I have to emphasize that her understanding this equitable weighing of factors, it applied to the second affirmative defense of unfairness. We lost that argument. That argument was struck. But all of those equitable factors that were so relevant to the first affirmative defense in this case are completely irrelevant they're irrelevant to the first affirmative defense, which relates to the defect of the acknowledgement. And finally, the rule that counsel is proposing, it's very interesting. where does the court derive its authority to fashion such a rule? It could be a good idea, but the issue here isn't whether it's a good idea to craft a rule. The issue is, where does this court get its authority to craft such a rule? It's interesting if there's, as long as there's a witness. So in other words, we're conflating the subscribing witness method with the acknowledgement method. Maybe that's a great idea. It's never been done before. Galetta recognized that these are two separate and distinct approaches. Even if it is a good idea, that's not enough for this court to act.
Yeah, but let me ask you this. Isn't all the statute requiring that there be an acknowledgement? So if indeed that is documented, that actually occurs, but it's documented later, why wouldn't that be within the statutory mandates? Why is that so far afield from what the statute requires? Aren't you staying with the core requirement?
I can only answer the way Galetta answered. The defect is that there was no, in the certificate, it didn't contain the appropriate language. That's not only a defect, that's a material defect. It's hard.
Yeah, but it fails to articulate what actually occurred. It failed to properly articulate what actually occurred, right? That she acknowledges it before a person who indeed knows her and whom she knows.
That's correct, but that requirement.
It's not like later on someone is trying to acknowledge it. It's not like the prior case, right?
No.
You agree this is not like the prior case, that 7 years have elapsed and there was never an acknowledgement.
That's correct. This was relatively contemporaneous as far as the certificate is concerned. That certificate has to be attached to be, they're not really separate documents. It either has to be endorsed or attached. It rendered it defective because it didn't comply with that third requirement. And appellant's position is that you can't get around the importance of that third requirement. You can't say, well, that's so much easily more curable. Why don't we just allow for a cure? There has to be first an answer to the threshold question. Should cures be allowed in the first place? And appellant thinks not.
Thank you, counsel.
Thank you.